I expect when I ask you what your plea is, there'll be no contest, right? So don't say guilty. So as to added count 2, assault with intent to commit the sexual penetration, how do you plead? Mr. Dodge, did you have an, oh, no, I got it. All right, so we're here today for a final pre-trial conference. We conducted that in chambers, myself and counsel. They informed me that today there will be a resolution in today's case. Mr. Carnes, why don't you go ahead and state the details for this pre-trial agreement today?
Yes, Your Honor, thank you. It's my understanding that the defendant will be entering a no contest plea to an added charge of assault with intent to commit penetration. That is a 10-year felony. People will be dismissing the charged CSC in the 3rd degree. There's also a Killebrew agreement that the defendant will be placed on a delay of sentence of up to 1 year. During the period of that delay, he will participate in the Youth Sex Offender Treatment Program in Kent County, or rather in counseling under that program. That is abbreviated YSOTP. And if he completes that program or is still compliant with him at the close of the delay, then he'd be permitted to withdraw the plea to this charge and enter a no contest plea to criminal sexual conduct in the 4th degree. There's a further Killebrew agreement that there would be no additional upfront jail at the time of sentencing.
All right, thank you. Mr. Dodge, is that a complete and accurate statement of the pretrial agreement between the parties?
Yes, it is, Your Honor.
All right, thank you. All right, Mr. Johnson, is that how you wish to resolve today's case?
Yes, sir.
Please raise your right hand. Swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth.
Yes.
You may go ahead and take your seat. Make sure that when we're talking today that you answer loudly enough so that Nancy in front can hear you and I can hear you, okay? She needs to be able to take down every word you say. Looking back at a date range of September 1st to December 31st, back in 2024, were you on probation, parole at that time? All right, were you on bond pending any felony charges anywhere else?
No.
Thank you. All right, Mr. Johnson, you were currently charged on a felony information, which is just simply a piece of paper, and you were charged there with a single count. That single count is a charge of criminal sexual conduct in the 3rd degree upon a person aged between 13 and 15 years old. Now, that is a felony that is punishable by 15 years and requires mandatory AIDS and STD testing and DNA taken upon arrest. Plus, it is a Tier 3 Sex Offender Registration Act case, which would require sex offender registration to be conducted for the rest of your lifetime. And they are done, I can't remember if they're annually. Nope, they're done quarterly. Anyways. Also, you can be subject to periods of probation as well, right? You understand that so far?
Yes.
Now, I'm told today that you're going to enter a plea of no contest to another charge. Let's talk about what a no contest means. Typically, at a guilty plea, I have to have the defendant answer a bunch of questions to explain why he or she is guilty of that offense. So they have to tell me what it is that they did. Now, a no contest plea is slightly different. Instead of requiring the defendant to make a statement, I'm going to look at something else, such as a police report, or in this case, the preliminary examination transcript. I can only take a no contest plea in a couple situations. One is potential civil liability. In other words, the person could be sued. And from what the attorneys have told me, that's the theory that we're using with today. And I see both counsel shaking their head yes. All right. But a no contest plea has largely the same impact as a guilty plea. We're going to talk about that. If you enter a no contest plea and I accept that plea, you would not have a trial. Does that make sense, sir?
Yes.
Now, that means you would also be given up certain rights that you would have at a trial. That includes the right to be tried by a jury, the right to be tried without a jury if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at the trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for defense to appear at the trial, the right to remain silent during the trial, and the right to not have a trial suits against you. Do you understand those rights?
Yes.
Now, actually, I know you probably have heard them already because your counsel handed me a form that at the top says advice of rights, and then it appears to have your signature. I'm holding it up. Is that your signature at the bottom? All right. So did you read through all this information?
Yes.
And even though I also just went over it with you, did you understand what you read?
Yes.
And again, even more importantly, you understand that by pleading no contest, if I accept that plea, you will be forever waiving these rights as they apply to this particular case.
Yes.
So now we're going to talk a little bit more about that pretrial agreement. I told you what you're charged with, but I didn't go over what you're going to plead no contest to. Sorry, I just ended in a preposition. I haven't gone over to what you will be pleading to. So I'm told today you're going to plead no contest to an added count 2. And if I accept that plea, count 1 will be dismissed. Now that added count 2 is a charge we call assault with intent to commit a criminal sexual penetration. Now that is a felony punishable by, instead of 15 years, up to 10 years. Also required sex offender registration for life, and it's done, I think, quarterly for that offense. Now, even though you might say 15 years to 10, does it seem like a whole lot? Well, it actually also goes down on what's called Michigan sentencing guidelines. It goes from a B grid offense to a D grid offense. So it also impacts potential sentencing. Now I'm told that there's another portion of this agreement. It's probably the most important for you. The agreement is that I would place you on what's called a delay of sentence. A delay of sentence allows me to basically not finalize the case, not finalize the sentence. Imagine if the sentence means when I whack this piece of marble with a gavel. Well, I don't do that yet. I basically hold the gavel and put it off to the side and bring you back in about a year. Over that year, you're not on probation, but you have terms that are very similar to probation. That may include no contact orders, it may include no alcohol, drug testing, things like that, and also that you can't violate the law. Well, one of the terms or conditions that would be a part of this is that you would be ordered to remain compliant with this YSOTP program down in Kent County, which, as I understand, stands for something to the effect of Youthful Sex Offender Training Program. That's what the T stands for. And if you are compliant with your terms and conditions of that period of deferral or delay, then you would have the right to withdraw your plea to the count 2 that I've talked about, that 10-year felony, and instead enter a plea of no contest to another charge called criminal sexual conduct in the 4th degree. Now that is a high court misdemeanor punishable by up to 2 years and or up to $2,000. And additionally, there's sex offender registration requirements as well, but they're a lot less. There, it would be biannual registration done for a period of 25 years. And it's what we call a tier 2 registration versus a tier 3, which is the most serious. All right, do you understand all that? All right, let's talk a little bit about what that sentence means, or that agreement means. We call it a Killebrew agreement. Killebrew is just the name of an appellate case here in the state of Michigan. And what it says is that you and the prosecutor, along with your attorney, of course, have reached an agreement. And if at the time of sentencing I don't go along with it, you would have the right to withdraw your plea. You might be sitting there thinking, well, it sounds like the judge is going to go along with it. There's probably a pretty good chance I will, but I don't know anything about it. Now, why I'm told that you don't really have any prior criminal history and you don't look old enough to have any significant criminal history. Sometimes, I don't know, you might actually be wanted for some case across the world. Maybe you've been running drugs and it's across off of whatever it's called now. But that's why I don't make that decision. But I really want to see how you find out more information about it. So if I don't go along with it, you can withdraw your plea. If I do go along with it, then we're going to continue to go along this program that I just got over with you. You understand?
Yes.
All right. Now, earlier I went over your rights with you, and then one more thing. Have there been any other promises, threats, or inducements of force or compel you to make this plea today that we haven't talked about?
No.
Okay. I also like to cover here with Mr. Carnes. Mr. Carnes, you've gone over the terms and conditions of this pretrial agreement with the plaintiff, I'm sorry, the complainant and her mother.
Yes, Your Honor, that's
correct. And as I understand it, they are aware of it, the terms, and are in support of the resolution. Is that correct?
That's correct.
All right, thank you. All right, so Mr. Johnson also has as you've probably talked to your attorney, he's probably giving you all kinds of information about sentencing guidelines and potential sentencings and things like that. Has he made any promise to you as to what exactly I will do?
No.
You've been able to speak with Mr. Dodge about this case and the charges, and you've looked at the police report and transcripts. Is that right?
Yes.
Okay, good. And you've gone to him and he's been able to answer all your questions for you?
Yes.
And are you satisfied with his counsel?
Yes.
And you believe that his advice in this resolution today is in your best interest?
Yes.
So I'm now going to ask for your plea. Now, I'm going to tell you what I expect you to say. It doesn't mean that you have to say it. But if I don't give you this warning, everybody in that chair says the wrong thing. So I expect when I ask you what your plea is, there'll be no contest, right? So don't say guilty. So as to added count 2, assault with intent to commit the sexual penetration, how do you plead? All right, before the court can accept that no contest plea, I need to take a look at some information. And as the counsel advised me in chambers, we're going to enter as the basis People's Exhibit number 1, which I have in my hands. This is the preliminary examination transcript. The prelim was held on August 18th of 2025 before the Honorable Court of Wiggins of the 84th District Court. Mr. Carnes, are you asking the court to accept this exhibit for the basis of the plea?
Yes, Your Honor.
And Mr. Dodge, does the defense so stipulate for its use for the plea and plea and sentencing?
Yes, Your Honor.
People's Exhibit number 1 is hereby admitted. I did look through that. It's not all that long. I did read it in chambers before coming out today. Mr. Carnes, do you believe the interest of justice do not require the defendant to recite a factual basis?
Yes, for potential civil liability. Your Honor.
And do you believe that the contents of People's Exhibit 1 satisfy the elements for the added count 2?
Yes, Your Honor.
Are you aware of any other promises, threats, inducements today?
No, Your Honor.
And you believe the court complies with Mission Rule 6.302?
Yes, Your Honor.
Mr. Dodge, do you agree with all what he said?
Yes, Your Honor.
All right, all right, good, thank you. Well, the court agrees that the interest of justice based upon what the parties have told me is really non-existent prior criminal history, the facts of the case, and what I've read in here. Again, the interest of justice do not require the defendant to recite a factual basis. The court also finds the defendant's plea today has been made freely, knowingly, and voluntarily. The court further finds that the information contained in the report again satisfies the elements for the added count 2. Therefore, the defendant is found guilty of added count 2, assault with intent to commit a criminal sexual penetration. Mr. Johnson, what's going to happen next is you're going to leave this courtroom and go downstairs to the probation and parole office, also known as the Michigan Department of Corrections. Now, I think you have a tether, right?
Yes.
So you got that at the office called the Community Corrections Office downstairs. No? Where'd you get it?
Through Manistee,
Oh, okay,
the GPS applies to
Yeah.
this count.
all right. Well, was there another case in Manistee? That's right, I recall that from a few months ago. All right, so when you leave my court, or sorry, I should never say my court. People's Court, and then I said the People's Court, and it sounds like it's a TV show. You're gonna go down the elevator, take it all the way down to the ground floor. When you step out, do a sharp button hook to the right. At the end of that hallway is a door. go through the door. It always sounds like I'm talking about a Dungeons and Dragons, go through the door. But go through it. At the end of the hallway on your left-hand side is the probation or parole office, also called the Michigan Department of Corrections. When you go in that hallway, there's only 3 windows. If you ask anybody, hey, where do I go from Judge Elmore's court? They'll tell you, okay? Now, they're gonna give you a packet of information. You're gonna complete that packet, and then you're gonna turn it in. You'll also be subject to an interview. That interview will be with an agent from that office. You have the right to have Mr. Dodge present during that interview. Now, this report that they're gonna prepare will talk about the pretrial agreement, what you were charged with, what you pled to, information about any prior criminal history you do or don't have. It'll also include the information that you provide while you're reporting this information to them. It could include a statement from any victim in the case. It will also include something called the scoring of the Michigan sentencing guidelines. Now, these Michigan sentencing guidelines are not mandatory. They just give the court a tool to help establish a reasonable and proportionate sentence. I just noticed there's one issue that I failed to cover in the pretrial agreement, but I'll get it in just a second, in case you're looking it up. All right. It will also include a recommendation as to what they think the court should do. Please keep in mind, it is strictly a recommendation. Nothing in there is mandatory. I alone get to make that decision. Understand, Mr. Johnson?
Yes.
So you're gonna leave here, go down there, get a packet, fill it out, turn it back in, schedule an interview, and then Mr. Dodge is gonna have to meet with you prior to coming back to this court, because he'll get a copy of that report, and the two of you need to go over it before I give a sentence or decide what to do. The reason is each side can come back and say, hey, Judge, this is wrong, this name is spelled incorrectly, this year is incorrect, or whatever, okay? Now, the one thing I forgot was, one of the terms or conditions of this killover agreement is after, if you're successful with that delay period, and you withdraw your plea, and then we enter a plea to the reduced charge of CSC 4, there was also a term of the agreement that there wouldn't be any additional initial jail. Additional means obviously you get credit for any time you served in jail, so I give you that credit, but you wouldn't have to serve any initial additional jail. That means that if I'll put you on probation, if you violate probation, then I can give you jail. Okay, does that make sense?
Yes.
Do you still wish to go proceed with the plea?
Yes.
All right, the court reaffirms its findings. Anything else today, Mr. Carnes?
Your Honor, Mr. Johnson and I were discussing, he wanted to bring a bond motion, and I think we've reached an agreement whereby Mr. Johnson has a radius, and I think it's fair to reduce that radius to 1 mile to the victim's house and school. He's prohibited from coming within 1 mile of both locations. I think it's bigger than that right now.
Oh.
I'd have no objection to reducing it to 1 mile.
Is that correct, Mr. Dodge?
Yes, it's been a little bit of a gray area on what the radius is, but I think we agree.
The court will modify the terms and conditions of the bond that the GPS radius will be 1 mile from the victim's residence. Mr. Carnes, hold on,
Oh, yeah, and her school.
and her school, and that school is?
I'm pretty sure it's Music High School.
All right, Mesa High School, and then I'm not gonna state her address on the record out loud here, but if you would please make sure that clerk has it. Let me take a quick look, maybe it's on it. I don't see it listed on the register of actions, so just make sure Madam Clerk has that address.
Yes, Your Honor.
All right, thank you very much. Anything else, Mr. Dodge?
No, thank you very much, Your Honor.
Good, otherwise, all your bond conditions remain in effect. Mr. Johnson, don't forget, go straight downstairs, button hook to the right. Walk straight. Thank you. We're adjourned. Yep.
Okie dokie. First things first, great granny, congratulations on your bingo. So for those of you who are watching who aren't familiar, we here at TCF created a bingo game for you to play along as you watch court. It's based upon the things that you see as you're watching. You can find that at tcfbingo.com. and that's available every day that we're live, so you want to check that out. Okay, so this defendant and the YSOTP program. One of the things I found interesting is this is a Kent County program, but this defendant is being sentenced in Wexford County. So apparently there's some county cooperation going on there now. But one program, and I grew up in West Michigan. I lived in Kent County for several years, so I'm very familiar with the area. And it's a very conservative area, and they tend to punish hard there. So this is interesting to me. But I was aware of a program called ASOTP, because that's been around for about 30 years now. But it's morphed into this YSOTP. The ASOTP was an adolescent sex offender treatment program, which dealt with kids under 18. But it's morphed into this YSOTP, which deals with people aged 17 to 24. It began taking participants in the fall of 2018. The program is offered to individuals between 17 and 24, as I just said, who have committed a non-violent sexual offense. So think like a 22-year-old getting with a willing 16-year-old. So not a violent situation, but still against the law. The YSOTP program is designed much like ASOTP was, to hold the individual legally accountable for their conduct and to focus on rehabilitation. Upon successful completion of the program, the individual may be offered a change of plea from their original charge to a different charge to permit them to avoid the harsh impacts of SORA. That's the Sex Offender Register Act. Talks about a grant. We don't care about that. Here are the highlights of the program. Either the prosecutor or the defense attorney identifies that the case appears to be one eligible for entry into the program. The prosecutor will conduct a review of the case to determine if his office will approve the case for psychological assessment. Step 2, psychologists from either the Men's Resource Center or Psychological Services will conduct an extensive assessment of the candidate utilizing interviews, collateral data, and a number of testing devices to determine if the individual is an appropriate candidate for the program. The assessment will balance the relative risks and amenability to counseling and whether the individual will ultimately benefit from the participation in the program. Attorneys receive a copy of the assessment report, and the matter is scheduled for a review. At the review meeting, the candidate and their screening results are shared and discussed with the team, and it is decided whether to approve the candidate for the program. If approved entry into YSOTP, the participant will enter a plea to an agreed-upon criminal charge and be given a delayed sentence to reappear within 10 to 11 months for sentencing, which is what we just saw happen. Upon successful completion of YSOTP, the individual will reappear for a change of plea to an offense that may not require registration to SORA. If the participant does not successfully complete the program, they may be discharged and have to register on SORA and be subject to additional court sanctions, including jail or prison. So that is what's happening there. It seems to be an intervention program designed for younger people who were not violent but still broke the law in such matters. It's interesting to me that it comes out of Kent County because, again, Kent County is very conservative and very aggressive with their sentencing traditionally. So, interesting, but that's what it is, and that's what he's been put into. So now we all know the rest of the story, as Paul Harvey used to say. Hey, thanks for watching this clip from TCF Live. If you enjoyed it, please leave a comment, like, and subscribe if you haven't already. And you can join us weekdays live, 9 a.m. Eastern, 6 a.m. Pacific, right here on this channel.